Hello everyone, I am Tejaswini, Bahadure, studying BA LLB third year, and I am here to explain the topic named Fundamental Rights versus DPSP, that is Directive Principle of State Policy, and who shall prevail if there is a conflict. Part 3 of the Indian Constitution covers the provisions of fundamental rights under Article 12 to 35. Fundamental rights are the basic human rights enshrined in the Constitution of India, which are guaranteed to all citizens. They are applied without discrimination on the basis of race, religion, gender, and place of birth, etc. These rights are enforceable against the state if state violates the fundamental rights of individual. Now let us know what DPSP are. Part 4 of the Indian Constitution covers the provision of DPSP under Article 36 to 51. DPSPs are guidelines or 15 principles given to the federal institution governing the state of India to be kept in citation while framing laws and policies. DPSPs lays down that the state shall strive to promote the welfare of people by securing and protecting as effectively as it may a social order in which justice shall form in all institutions. DPSPs are unjusticiable, that is non-enforceable in the court of law. Both fundamental rights and directive principles are concerned with state actions, while DPSPs are positive directions that are to be kept in mind while making laws, and fundamental rights place limitations on the state to prevent the arbitrary use of the state. There always arises a question that what is the relationship between fundamental rights and directive principles? Who is superior, fundamental rights or directive principle? Who shall prevail if there is a conflict? So, it is said from the olden days that as fundamental rights are enforceable in court of law are superior, and as DPSPs are not enforceable in the court of law, it is subordinate. But time passed and many decisions were given by Supreme Court which changed the thinking time to time. The question of relationship between directive principle and fundamental rights has caused some difficulty, and judicial attitude has undergone transformation on this question over time. Initially, the courts adopted a strict and literal legal position in this respect, and the Supreme Court, adopting the literal interpretation approaches to Article 37, ruled that a directive principle cannot override fundamental right, and that in the case of conflict between two, the fundamental right would prevail over the directive principle of state policies. This is the old thinking, and as time passed, there comes many cases. We will talk about these cases one by one. The first case is Champakam Dorairajan case 1951. Supreme Court in this case stated that DPSP should conform to whatever is being said in fundamental rights. Here it is said that fundamental rights are superior and directive principles are subsidiary. And it was their thinking in 1951 that directive principle have to work through fundamental rights. But perspective changed over time in well-known case Kerala Education Bill 1958. In this case, Supreme Court began to assert that there is no conflict on the whole between fundamental right and DPSP. They are complementary and supplementary to each other. Here it is said that why there will be a conflict when Constitution was made? It was made after thinking about each and every aspect. So these two parts do not conflict each other, they work with each other. Supreme Court are emphasized that the fundamental rights and DPSPs formed an integrated scheme which was elastic enough to respond to the changing needs of the society. Then comes Golaknath versus State of Punjab 1967, and here again thinking changed. Supreme Court here observed that fundamental rights and DPSP constitute the conscience of the Constitution. There is no antithesis between the fundamental rights and directive principles, and one supplements the other. Both Part 3 and Part 4 have to be balanced and harmonized with each other. And then comes the next case, that is State of Kerala versus N.M. Thomas 1976. Supreme Court here said that the directive principle and fundamental rights should be construed in harmony with each other, and every attempt should be made by court to resolve any apparent inconsistency between them. Means Courts should try to solve dispute between fundamental rights and directive principles. They should make every possible attempt. Then comes Minerva Mills versus Union of India 1980. This is one of the most important case laws, and in this case the Supreme Court observed that fundamental rights are not an end in themselves but are the means to an end. It means we don't have to achieve fundamental rights, we have other goals, and to achieve those goals fundamental rights is a means. This is a road which takes us to our end, and end is specified in directive principle. Fundamental rights and directive principle together constitute a core of commitment to social revolution, and they together are the conscience of the constitution. And the constitution is founded on the bedrock of the balance between fundamental right and directive principle. To give absolute primacy to one over the other is to disturb the harmony of the constitution. This harmony and balance between fundamental right and directive principle is an essential factor of the basic structure of the constitution. It is in the sense that fundamental rights and directive principle together constitute a core of our constitution and combine to form its conscience. Anything that destroys the balance between the two parts will ipso facto destroy an essential element of the basic structure of our constitution. Then comes Ashok Kumar Thakur versus Union of India 2008. This is the case of 2008, and this is recent case. In this case, Supreme Court observed that no distinction can be made between the two sets of rights. Here, fundamental rights represent civil and political rights, whereas the directive principle embodies social and economic rights. Merely because the directive principle are non-justiciable by the judicial process do not mean that they are subordinate in importance. It may be concluded by saying that one should try to establish harmony between fundamental rights and directive principles, since maintenance of harmony between them is the basic feature of the constitution. The directive principle and fundamental right are regarded as supplementary and complementary to each other. The directive principle, which have been declared to be fundamental in the governance of the country, cannot be isolated from the fundamental right. The directive principle have got to be read into fundamental rights. An example of such relationship is furnished by the right to education. At the same time, the values underlying the directive principle have also become enforceable by riding on the back of the fundamental rights. Courts have used directive principle not to resist but rather to expand the ambit of the fundamental rights. The theme that fundamental rights are but a means to achieve goal indicated in the directive principles and the fundamental rights must be construed in the light of the directive principles as advocated by Supreme Court time and again. So, there is no conflict between fundamental rights and DPSPs. They work with each other and supplementary and complementary to each other. Thank you.